Welcome. I'm Ann Urkowicz, Membership Engagement Manager, and I'm going to get started right away in the interest of time, but we'll have people continuing to join us, as I go through our welcoming remarks, and we hope that everybody is, able to get in before the presentation begins. So welcome to Save the Sound's quarterly Lunch and Learn series. This afternoon, we're proud to welcome Idan Rotenberg, partner at Super Law Group, and Roger Reynolds, senior legal director at Save the Sound. Idan is a litigator and partner at Super Law Group, a team of water lawyers for the environmental movement. Super Law Group has helped the Waterkeeper Alliance and numerous waterkeepers across the United States and Canada fight for swimmable, drinkable, fishable waters in various federal and state courts and before governmental bodies. Idan is a graduate of the Yale Law School and holds a master's degree in environmental management from the Yale School of Forestry and Environmental Studies. He's published research on topics including energy efficiency, climate change, and grandfathered pollution controls in environmental law. Idan also served as an advisor to the United Nations Development Program, climate change, and to a United Nations Environment Program project on civic participation in environmental issues. Roger Reynolds is our very own senior legal director at Save the Sound. Roger directs cases and legal matters for Save the Sound to protect Long Island Sound, inland waters, land, and air. He is also an adjunct professor at UConn School of Law, where he established and teaches the Environmental Law Clinic and teaches negotiation. Don and Roger will be sharing how chronic long-term sanitary sewer overflows from aging infrastructure can be successfully addressed through a combination of sewage right to know laws and Clean Water Act litigation. Please feel free to raise hands throughout the presentation and/or use the chat function with any questions you have as we go along. We'll also welcome questions at the end. And if you have questions during the presentation, Amanda and I will try to help jump in with those questions. All right, and with that, I'll hand it over to Roger. Thanks.
Great. Thanks so much, Ann, and thanks everybody for joining. Really appreciate you tuning in to hear about this. I'm going to take a moment and share my screen here. Okay, is that coming through, Ann? Perfect. So, yeah, like Ann said, we're going to talk today about what we're calling crisis to compliance, and that's how to address a regional sort of aging sewer system that's in a state of disrepair and resulting in pollution to the waterways. And it was a problem we discovered coming into our Westchester office, and it was really the first major problem we dealt with, especially with respect to the sound in that office, and it's still somewhat in progress, as you can see. Ann talked about the two organizations a little bit, but Save the Sound, as you know, we work on climate change, endangered lands, the sound and its rivers, and we restore ecosystems. The legal component has, from day one, has always been a significant part of what we do, and it remains that as much as ever. Recently, we've been able to grow our legal department of attorneys who are actually practicing law. We have a lot of other attorneys doing other stuff as well. But the attorneys actually practicing law are me. I've been able to become a full-time senior legal director, and there are 3 full-time attorneys working with me, one of which is centered in New York. And so we have more resources than ever, and we're very excited about that. And then, really happy to be joined by Idan. We've just been realizing we've known each other and been working with each other for 13 years now, and I've been working with Super Law Group even longer than that, maybe 20 years. But they're great resources to have, and as we'll talk about before, we have the resources to maybe take on 1 or 2 municipalities, but to take on 11 municipalities and a county all at the same time, we really needed the outside resources that Super Law Group brought to bear. All right, so this is the Long Island Sound watershed, and this is the problem. You see relatively small Long Island Sound here, and the huge watershed, 6 states in 1 province, Quebec up here, all of which contribute pollution to the water body. As our report card is stating, we've made really significant progress since the 1980s and 90s, but as we'll discuss today, we still have a ways to go. And in particular, nitrogen pollution and raw sewage pollution, which causes bacteria, harmful bacteria and harmful algal blooms, is on the docket today. And today we're particularly talking about Westchester County. And this is a more localized version of the immediate watershed. And you all know where Westchester County is located. We gave this presentation nationally and had to give a little more context on what Westchester County was. And so this is why we're in Westchester County. We opened our office in 2013 and 2015. Before that, we'd been in New Haven. And what we found when we got there was widespread sewage overflows. And that was problem number 1 that we knew we had to address. What we did was we mapped them, and that's the map you can see here. And these were all the sewage overflows that were taking place. And they're taking place because of aging and failing sewage infrastructure that was owned and controlled by different actors. So you have the series of everybody pointing at everybody else, including governments. There was government inaction at the federal, state, county, and municipal level. And there had been reported enforcement for over a decade, but nothing was really happening, and there wasn't really meaningful enforcement in our view. So how did we get this information? It was reported by watchdogs. We got calls in about the sewage overflows, but mostly it was garnered systematically from the New York Sewage Pollution Right to Know Act, which was passed in 2013. As you recall, this was around the time of Superstorm Sandy and Irene, which were alerting us to the new reality of these huge storms and the consequences of the billions of gallons of sewage that were discharged. And both New York and Connecticut figured out at this point, and these were the first in the country, to pass sewage right to know acts that the public needed a right to know about which water bodies were being polluted by sewage at what point.
Hey, Roger, can I jump in for a second?
Please do, yeah.
Great. Hi, everybody. My name's Idan. I've been introduced already. I want to just quickly, before Roger moves on to what is a sanitary sewer overflow, just say that, you know, the problem that Roger's talking about is not unique in any way to Connecticut. It is a fundamental problem across the United States. So our firm, as Roger said, we do work for keepers around the country. We partner with Save the Sound on this case, but I've brought sewage cases in very similar circumstances. I've been involved in 3 cases like this in Florida. I'm currently in 1 in Alabama. There is an infinite number of these cases we could be doing, unfortunately. And that's because the deep problem is that most of the country has aging infrastructure, in this case, sewage infrastructure, that is chronically underfunded, right? And so these pipes are very old. They are easily, 50, 100 years old in some places. Their lifetimes are not 100 years. Their design lifetime of a clay pipe or a steel pipe is not 100 years. So they're past their lifetime. And on top of that, they are not being replaced. They're not even being systematically maintained. And that is the root problem here. And to take on a problem like that really requires a great environmental organization like Save the Sound. The reason that my firm works with Save the Sound and groups like Save the Sound is because you need a partner locally that is well organized and has the depth. This is not an easy problem to take on. These are multi-million-dollar deferred infrastructure problems. Every city council for years has put it off, and now the bill is coming due. There's sanitary sewage in the street or in the harbor, and somebody has to pay for it. That means it's going to be a big fight, but it also means there's a lot of data gathering to do, right? And that's the first thing Roger talked about. You have to be able to map you have to be able to gather data on where are these sewer overflows happening. It's great that there's a Sewage Pollution Right to Know Act. It made it easier to gather that data because states and municipalities and local sewer operators need to report to the state every single time that there's a spill. And there's one centralized database that you can go to get information about every sewage spill that has happened in New York since 2017, whether it's 5 gallons or 5 million gallons, they're all there. That's great. You still need to take the time to break it down, do the analysis, figure out where they're happening, why they're happening, and invest over many years in research, case development, and engineering to tackle a problem like this. And it takes a really solid partner. And that's why I feel lucky that we have Save the Sound here. But why these problems are hard to deal with is you need an organization with the kind of depth that Roger was talking about. An attorney, a senior attorney, 3 junior attorneys, and a whole environmental and technical staff before you can really, or you need to one or the other, but you need depth and you need patience. So I wanted to give some credit to Save the Sound for that. And now let's move to the details.
Thanks. And to that point, we're talking about New York today, but we've also brought a number of these cases in Connecticut. We've done that more on our own because they've involved individual municipalities, but Darien, Danbury, West Haven, Bridgeport, all of those we've engaged in some kind of discussions on these. So sanitary sewer overflows, what it is when the system gets overwhelmed by rainwater, which shouldn't be getting in there in the first place. We'll talk about how it does. But it's too much for the system to handle, so it literally blows out, and this is sewage going onto the street. And then the reason why the Clean Water Act is involved here is because it goes down storm drains and ultimately reaches a water of the United States. So why is this happening? Like we said, it's aging and under-maintained infrastructure. So you have the pipe here, and this can be a municipal or county pipe, and the cracks allow groundwater and rainwater in, which overwhelm the system. But then you also have the lateral pipes, which go to the homes and are actually owned by the homeowners. So it makes it that much trickier to get these fixed. They also are in an age of disrepair. It's older infrastructure in an older municipality, and roots can get in. And then you have faulty manhole covers, which have been improperly maintained, and they can let water in from the top. And then you also have what we call inflow, which is water that should not be, rainwater that should not be directed to the system, which is illegally directed into the system. And this can come from roof drain connections, roof drains that go straight to the sewer system. And sewer systems were meant for sewage, to carry sewage, not to carry water from your gutters or from your foundation drain, which can also be connected, or something that this diagram doesn't have, but is maybe the major source is sump pumps can be directly connected into the sewer system, flooding it when it rains, leading to these situations and the maps. So what does the infrastructure look like? This is a map of the sewage system in Westchester County in the Long Island Sound watershed. And what you see here are 4 regional sewage treatment plants, even though they're named after towns they're in. They serve multiple towns, so it's a little confusing. Mamaroneck serves New Rochelle, along with New Rochelle serves Mamaroneck and New Rochelle. So at any rate, what you're seeing here are the trunk lines that are owned by the county. And what we found is these were actually fairly decently maintained, and the plants were not necessarily poorly run in our view when we investigated. But the problem is all these pipes have to be connected to the rest of the community, and that's where the municipal pipes come in. There's a whole nother pipe system that's not shown here, which is 95% plus of the mileage of the pipes, which connect it to the homes. And that's where the infrastructure was not being maintained. That's the responsibility of the municipalities, and these require large investments in aging cities, so it's not necessarily done. And you know, this tends to be some of the wealthiest zip codes in the U.S. I mean, it does have Port Chester and New Rochelle as well, but it is aging. But there are resources here to handle it if there's the will. And then you have the homeowner's lateral lines, which contribute both infiltration and inflow. And we talked about that a little, and we'll talk about it more later. And this is just to show how the districts are organized. The Portchester district serves 3 towns: Portchester, Rye, New Rochelle, 4 towns. So it's a very complex system. And again, all of this and the different actors and the lack of responsibility and lack of enforcement is resulting in this, which is unacceptable. So our first step was to investigate, to gather the information about the flows and to map them. We wanted to establish the cause and really understand it. We believe that inflow and private laterals are a very significant part of the problem. Fats, oils, and grease, that's restaurants discharging, usually restaurants discharging, putting grease directly into drains without proper filters is a bit of a problem, but really the lack of maintenance and, again, the different actors owning different parts of the treatment system. So what we did was we contacted the municipalities and the sewage treatment plant to enter into discussions. We had to construct a legal theory, and we believe this was violating the Clean Water Act and constituted a public nuisance. Clean Water Act, you can't discharge pollution into the waters of the United States without a permit. There are no permits for overflows. And public nuisance, they're engaging in unauthorized activity which pollutes the waters, which is a nuisance to all the public. We wanted to go after all of the contributors, whether it was the plant or the collection system owners. So the county was the permit owner and the one who was actually permitted. And we had a better case against them. It was a simpler case. They were subject to greater liability. It's kind of an open and shut case because Clean Water Act is strict liability. But we felt the towns were actually more at fault. They were the ones who were not investing in the infrastructure, and it was their responsibility. So we wanted to get them in, but the theories were admittedly less clean, but as we'll find out, sufficient. And this is an incredibly important part of what we do. Municipalities, we as a environmental organization that does a lot of different things other than just Clean Water Act litigation, we partner with municipalities on a number of things. We're joint funders, with them. They fund some of our stuff, and you need to work with municipalities to address the actions within municipalities. So we always want to reach out before suit, and we always want to settle it. Like I said, in Connecticut, there were a number of actions where we never even brought suit, never even filed suit and settled. There were a number of actions where we negotiated a resolution to file in court before we filed it. And there were actions where we had to sue. So reaching out to the parties is always very important. We start with a telephone call to the town supervisor. And if, which is, you know, they call him first selectman in Connecticut, and it's basically the chief elected official. If we don't have a particular connection with them, we ask someone who does to call them to get their attention. Sometimes they'll respond and sometimes they'll talk. Rarely will they meaningfully talk because, like Don said, these are huge amounts of money, significant investments, very painful things for municipalities to do. So they usually do not want to engage in serious discussions along the magnitude that we would need to solve the problem at that point. We follow up with an informal letter. This is not a 60-day notice letter. It's not a formal pleading, just outlining our concerns to make sure we have a written description to the town supervisor. And then again, we follow up with phone calls and try everything to reach out. A surprising amount of times, they completely ignore us, even if we know the person. And then after being completely ignored, once we do file suit, they say, why didn't you talk to us? And so we really very carefully document this whole process and then sort of show it to them that we talk to them. And sometimes that makes a difference, sometimes it doesn't. But that's a very big part of what we try to do is settle it as early as we can. We were unable to engage either the county or the towns in the serious discussions that we needed to, so we did file suit. And usually when negotiations start in situations like this is the first appearance in court. That's when they've talked to their attorneys, they've understood that these are real theories and that they're subject to significant exposure and they have to deal with this. And that's what happened. They showed up and, we went off to the side and talked, and the towns agreed they needed to act regardless of Clean Water Act liability. So they didn't admit Clean Water Act liability. They didn't want to get into those issues, but they said, we do want to address the situation. We know there's a problem on our hands. We know we have to act. We've got to fix our infrastructure. So what they agreed to do is study their collection system to identify defects. And this sounds pretty straightforward, but these are called SSESs, sanitary sewer evaluation studies, and they can cost millions of dollars in and of themselves. So this in and of itself was a pretty big step to get them to seriously study their system. And then they would share the studies with us and our engineer. Having a good engineer, as I'll talk about, is really important for these cases for feedback. And then we'd seek to agree on, what repairs needed to do to get them back into a state of good repair. And then at that point, we would reassess what, if any, issues remain for the court to decide. And so the judge ordered them to do these SSESs. It was a consent order. They agreed to it. But we did have a court order that they had to do these studies and share them with us within a certain amount of time. But then pursuant to that, the case was stayed and the judge required quarterly reports. And this was hugely important. It was also hugely important that we had a very engaged judge who clearly wanted this to get action to be taken in some form or other. So the quarterly reports don't sound that frequent, but they come up pretty quickly and they were really key for accountability. And if a town is a month and a half behind on something, you put in the quarterly report, they're a month and a half behind. The town doesn't want to put that. So sometimes they'll correct it. Sometimes they won't. And if they get too far behind, we would ask the judge to take it off stayed status and put it back on the litigation docket. This was kind of a last resort. If we'd asked the town like several times and they'd ignored us, which happened more times than I care to admit. But that usually did get it going. And it got us back on settlement talks with one exception, which I'm now going to turn it over to Don to talk about litigation.
Sure. Before I jump into that litigation there, I just want to emphasize that the amount of time involved in what Roger is saying and the amount of effort, right? So once we have a town's attention, they need the time to study their system. And that means when we start the case, we know that there are sewage overflows and we're not 100% sure why. We just know that there's a lot of them. There's a lot more than there are in other towns. And we do our best to try to understand, is it, as Roger said, failing, underfunded infrastructure? Is it fat, oil, and grease? Are there a lot of restaurants that are dropping, the deep fryer down into the system? Is it something else? We do our best to know what we can from publicly available knowledge on the outside. But at the end of the day, there is no substitute for the city getting into the hundreds or thousands of miles of sewer pipe that it owns and giving them a really thorough inspection that is many, many years overdue. And as Roger said, that's a multi-million-dollar process in some cases. It's at the very least, a six-figure process, even in smaller towns. And it takes time. And then the results need to be held to some kind of national standard. There are national engineering standards for how these assessments are done. It is a long and slow process, and you can understand why cities are reluctant to do it, because you're just pointing out something that is painful and difficult, which is, the chickens are coming home to roost. You've ignored this problem for so long that now it's massive. Just getting your hands around how big the problem is takes many, many months and many hundreds of thousands of dollars, only to discover what the actual bill is going to be. Imagine that you have a problem with your car and you go to the mechanic and the mechanic says, it's going to be $100,000 to diagnose the problem, right? That's where they are. Of course, they hate it. It has to be done. It has to be done. It happens because generations of leaders before them have chosen to underfund their infrastructure, and this is what happens. You can't. Maintenance is expensive, whether it's bridges or sewers or your house or your car. Not doing it is not an option because eventually you end up with problems like these. So, as Roger was saying, faced with the reality of that, most towns agreed to get into a process that takes time. And I want to stress this case was filed in 2015. It is now 2024. We still are not finished. Some of these towns are still doing repairs. Some have finished. Some are still doing repairs and will be doing repairs for many more years. It's a lot of money. It's a lot of time. You need to be flexible. You need to be patient. What matters is that it's a big ship, but it's now moving in the right direction. And each town is moving with what we think is about as much speed as they can. With one exception, everybody came to the table pretty quickly. And one group of towns, the towns in the New Rochelle Sanitary Sewer District, decided that for a variety of reasons, they did not want to just enter a settlement, get on this long pathway of assessment, cleaning things up, and agreeing with us on all the other issues, because there are other issues. As Roger said, it's not just about getting into a state of good repair. Now we need to also figure out, once you've got a plan for getting back into a state of good repair, how do we fix the process that you use to manage the system so that you don't end up in a state of bad repair again? How do we make sure that you do inspections more frequently than you did in the past so that when things are in disrepair, you find them? How can we be assured that in your budgeting, you are actually putting aside money for depreciation and replacement of assets? All those questions need to be addressed too. All of that takes time. But everyone else was willing to come to the table and talk. For a number of reasons, some of the towns were not. They chose to move to dismiss the case. They basically said, we don't need this litigation. We can fix this problem without the litigation. There's no room for this litigation, and it has no legal basis. As Roger said at the beginning, we thought the best case was against the county. The cleanest case was against the county. Their name is on the permit. The permit says no overflows, and there are overflows. But we thought we had good claims against the towns too. And by doing this, by filing a motion to dismiss, the towns gave us a chance to get a really clean shot at understanding whether or not we had a good theory. Do you want to move to the next slide, Roger? Did you want to skip this? So the theory, the court basically bought the theory perfectly. And I'm not going to read to you what the court wrote. You can see it yourself. All of that is text directly from the opinion. But the gist of it is that the defendants, the cities, were not able to say, hey, the county owns the permit, the county owns the plants, therefore this is a violation of the county's permit and it's just the county's problem. The court got the basics of how a sewer system works. These defendants, these towns own pipes. They own 95% of all the pipes. And they're discharging so much flow through their pipes that they are causing the county's pipes and the county's sewage plants to overflow. Not only are they overflowing out of their own pipes at various points, not only are there overflows in the towns from the town pipes, they are also sending so much sewage into the county's pipes that there are problems further down the system. And the court judge said that they should be held responsible both for overflows that happen from their own pipes and when their overloading of the system causes somebody else's pipe to overflow. The bolded part at the end is really the key to it, that a person is liable for the discharge of pollutants, even if it passes through a conveyance, in this case, a pipe that belongs to someone else. If you put that material in the pipe and it ends up in the water, under the Clean Water Act, you can be held responsible, which in this case was the important principle that everything turned on. So essentially, if you want to go to the next slide, what it looks like is this picture of which I believe is a rain gutter system in Italy. But the idea being, if all of these satellites pump a little bit of water into that one big pipe at the bottom, and the big pipe at the bottom overflows, that is as much the responsibility of all the people who own the little pipes. That was why we brought in all the towns, and it worked. The other thing that the court said, if you want to just go to the next slide, is that you cannot hide behind somebody else's permits. So the 4 towns that decided to try to get rid of the case tried to argue that since there was only one permittee and these violations were violations of that person's permit, the only person who could be held accountable was that permittee, was the county. If the county owns the permit, only the county can be responsible. And the flip side of that, that the county's permit therefore protects everybody else. Everybody who's behind the county can hide behind the county's shield, like in this, illustration of a shield wall. That doesn't work, the judge said. The only person who can hide behind your shield is you. If you are a permittee, you are taking on the responsibility of the permit. You're allowed to discharge in exchange for agreeing that you will properly maintain your factory or your sewer system or whatever it is that is causing pollution, and that you will carefully monitor and regulate the amount of pollution that the government is permitting you to put into waters of the United States. If you have not taken on those obligations, you cannot hide behind that permit. The concept of what's called a permit shield is an important one in Clean Water Act litigation, and it was important to us to get that decision saying that it does not work to protect people who don't have a permit. It only works to shield the person who has voluntarily taken on the obligations of the permit. So with that, I'll return it back to Roger once that motion was dismissed to talk about how we got everybody back onto a settlement track.
Yeah, and that decision unfortunately was not published. It was read from the bench, but we definitely have a transcript of it. We definitely have it prominently bookmarked for our next case. So these settlement pathways all took place in various different ways, but they all came, they were all basically one-on-one negotiations. It was a very time-intensive process. But we got the same basic relief in every settlement eventually. And that was study the defects, as we said, we got that early on. Agree on a plan and schedule for repairs. That came earlier on at some points. It came fairly recently in some cases. Change their management practices, adopt best industry practices. And this is very important. So the repairs address the problem going backwards of having failed to keep the system in good shape. The management practices address the funding of the system going forward. So to us, that's a key part of the relief. We don't only want to see you get it into shape now, and then we'll be back here 10 years ago when it all falls apart. We want to see these management practices where you're keeping it in shape and you're inspecting it and making the fixes at the right times, not whenever you get sued. Resolve the financial components in terms of fees or penalties or environmental benefit payments, which we'll talk about. And the private lateral program, we wanted them to address that either through an ordinance or an insurance program, which again, we'll talk a little more about. But that was a way for the municipalities, even though they don't own these private laterals, to use their regulatory authority to compel the owners of the private laterals to take the appropriate action when they have the resources. Some of the steps are sequential, some of them are parallel, and they all came, but these basic components were included in every one. The private laterals, again, we thought that after our investigation that a really big component was both the inflow from roof gutters and basement drains and sump pumps, and the disrepair of private laterals. So this was not addressed by the sanitary sewer system evaluation studies because they were private. So one thing we did is required municipalities to pass an ordinance, and that would require before a sale or before a major renovation to have an inspection by a certified plumber and to certify that there are no illegal connections and that the laterals are in good working order. The best way to address these is what we call an insurance program, which is not actually an insurance program, but that's the best way to describe it and talk about it. And what that does is for, few tens of dollars a month, you can be part of this program where each house contributes, and then the municipality will take that money, they'll hire the contractors, they'll discover the broken laterals, and they'll fix them in the order of priority. And if you pay into that insurance program, which is a reasonable payment, everybody can manage it, it's like another utility, then you have no more responsibility. It's now the municipality's responsibility. If you opt out and say you don't want to do it, then you're subject to inspection and you're on the hook for it, however much it costs and whenever you have to do it. We've seen these programs done as opt-in or opt-out. As the name suggests, opt-in, you have the opportunity to join the program. Opt-out, you're included in the program unless you specifically opt out. We have found the opt-ins are not very successful. It's behavioral economics. People don't want to incur themselves a negative burden. But opt out, they're less likely to take the affirmative action to opt out. So Harrison in particular has agreed to do an opt-out program, and we were very pleased with that and looking forward to seeing how that goes. There really should be funding for low-income residents because this is a big burden. It's almost impossible for truly low-income residents. Like we said, these are very wealthy zip codes, but they do have a decent amount of low-income residents too. So that really should be a part of that. That wasn't in this case, but we would like to see that moving forward. So for all the municipalities, and the county is still pending, we haven't settled that, keep that in mind. But all 11 municipalities have now settled, and in total, they've agreed to study and repair more than 642 linear miles of sewer pipe, fix more than 64,000 of the identified defects. And we don't have official numbers on this, but this was well over $100 million in total, probably several hundreds of millions of dollars. But we didn't track that separately. And then 1.23 million for environmental benefit projects to restore and protect the waters that were polluted. And what an environmental benefit project is, so if you bring a clean water action and you win in federal court, which is where we brought this, then you're entitled to civil penalties for violations. Those civil penalties by law go to the federal treasury. And get used for whatever the federal treasury wants them to use, not even necessarily federal environmental stuff. It's just treasury stuff. If you settle a case, you can make, by agreement, that money can go to restore the local environment, which is a win-win-win. The municipalities would rather have this too. They'd rather have, if they're going to pay 1.23 million, they want it to solve pollution problems in their communities. And we certainly want that. So that's where these environmental benefit projects come from. It's basically money in lieu of penalties that goes to improve Long Island Sound and local waters. So basically, for people who know these municipalities and are interested, there were sort of three different ways settlement occurred. Three towns, White Plains, Village of Mamaroneck, and Portchester, wanted to settle very quickly. And we got this done in the first 2 years. They didn't even want to share sanitary, their studies with us and go back and forth. Their theory was, we know our systems. We don't want to be told by you and your engineer how to manage our systems. We know we have an obligation. We'll do it, and we'll agree to do it. It was sometime between 2018 and 2020, they all agreed to do it. Nobody achieved this. Some of them just completely dropped the ball and didn't really pick it up until 2020. But we had to enter into subsequent enforcement orders with each of these towns. And instead of that very simple order, the final consent orders ended up looking a lot more like what we went over before with all these various pathways. So over 8 years, the four towns, Rybrook, Scarsdale, Rye, and Harrison, we reached that pathway independently. It took a longer time than it should have, but we did reach that. These are admittedly very complex, very difficult situations involving a lot of money. And then Edon talked about the litigation with the members of the New Rochelle Sewer Service District, which were New Rochelle, Town of Mamaroneck, Larchmont, and Pelham Manor. The judge ruled in our favor after, decent amount of legal resources were spent on a motion to dismiss, and some resources were spent on preparing for trial. But the towns ultimately agreed to a settlement along those same lines. And you all are thinking 100 million, hundreds of millions, that's a lot for these towns to be spending, and it is. Fortunately, like Connecticut, New York has adopted an infrastructure clean water fund, which helps pay for a substantial amount of these. It's hundreds of millions a year is actually, yeah, hundreds of millions a year is budgeted for these, and were available to the town. So they got a lot of assistance in meeting this. And that has been key all over the whole Long Island Sound watershed in Connecticut and New York for cleaning up the watershed. Connecticut allocates about 300 million or so per year to a clean water fund. Unions and environmental groups have combined to lobby for that because it makes good union jobs and it cleans the water. And that's why we've made a lot of the success we have made. I go around the country and talk about the success in Long Island Sound, and then I say, well, the legislature gives us 300 million a year. They're like, oh, well, yeah, if you get that, no problem. And that's true to a certain extent, but it's hard to get that, and it's important. And all of these things cost, and it's important for the state to fund it. The county is still pending. We haven't settled with them. We've had an interesting relationship with them. In some sense, they are glad to see us getting the municipalities to comply. But in some sense, they're also a defendant. And we decided to resolve all the issues with the municipalities, and then the issues with the county would be more defined. And so primarily what we're looking for, the county has had the ability to enforce against the municipalities in the way we have, and actually a much stronger ability. They have a separate law called the County Sewer Act, where they can require municipalities to discharge less into their systems. Politically, or for whatever reason, they haven't been willing to do that, and they've failed to do that. In fact, part of their Clean Water Act permit said they had to enforce these limits, and part of our case was they had failed to. So a big part of what we want is for them to enforce the limits on flow against the municipalities. In connection with that, we want them to flow monitor towns and monitor how much they are discharging and when they go over that. Blending issues, to make a long story short, this is when the system gets overwhelmed by too much rainwater, and to avoid blowing out the plant, they partially treat the sewage and then reblend it with treated sewage. The theory is it's treated and it meets permit limits. We're not so sure of that reality. We believe it's not monitored often enough. So these are in play with the county as well. And then we're also negotiating potential environmental benefit projects or payments. Those are in process. We have not settled anything yet, but I think I can say that we're optimistic. So other solutions, litigation is great. Sometimes it's the only solution. But other solutions that would go a long way are requiring municipalities to be co-permittees. We talked a lot about how the county was a permit holder, and it made it tougher to go after municipalities and made it tougher for municipalities to recognize their obligation. So EPA actually and DEC has the authority to make them co-permittees to make it more enforceable against them. intermunicipal cooperation. The New Rochelle Sewer Service District towns actually work together to negotiate and to solve these problems. We'd like to see a lot more of that. And then the big kahuna, consolidate and centralize all the collection systems with the county. As we said, the county actually manages their system fairly well in our view. And the municipalities don't and don't want to. So there's a group advocating, including us, for the county to take these over. The problem is, it's hard for the municipalities to pay the county what it takes, and it's hard for municipalities to give up authority to decide who connects to the sewer and who doesn't. So these are complex negotiations, and we hope that will go through. Lessons learned, eternal vigilance is the price of clean water. If you stop working on these, if your energy lets up for a moment, the pollution's going to restart again. So yes, this was slow. It was 9 years. It was time intensive. We had to really work one-on-one with municipalities through very complex plans. Experts were needed. We needed an engineer with extensive expertise, and we are so lucky to have a brilliant engineer who is able to go toe-to-toe with municipalities on their own, on how to operate their own systems, and is, almost always right, and does not get proven wrong. We've had to enter additional enforcement consent decrees with many municipalities, including Rye, Village of Merrimack, White Plains, and Port Chester. So you got to keep going. These are long-range problems. They require constant monitoring and follow-up. Part of what we're looking for with the county is to do this follow-up, but we are doing it as well. Part of our settlements, we get compliance fees. That's attorney's fees in advance for the need to monitor compliance going forward. And that's been hugely helpful in enabling us to continue to monitor these problems and continue to address them. And they're still very much in progress. So that's the case. I just want to talk about sewage overflows for a little while and what you can do. If you witness sewer overflows in your community, keep an eye out for that. And when you see them, take pictures and email, save the sound, or just report it if you're unable to do that. And the email is pollution@savethesound.org. Any type of pollution, obviously, you can report through that as well. And we'll take a look at it. New York, if you want to sign up for the sewage pollution right to know alerts, you can go to this web address, alert.ny.gov. It's a somewhat complicated process. You have to sign up, create an account, and then you click by location. And this is like an emergency notice system for all sorts of stuff. So you have to unclick everything unless you want other things, but make sure the sewage pollution is clicked. And then you can, every time there's an overflow in Westchester County, you will get an email telling you exactly what the overflow was, how much, what water body it reached, how much reached it. And incredibly valuable for staying alert to what's happening. Connecticut also has a sewage right to know information. We do, despite the fact that the law requires it, 22A-4, 24A-4, we do not have a real-time alert system set up. They have a Twitter account, which has not been active for a couple of years now. And we are working with them and the legislature to do that. But you can go to the site and you can, it's not intuitive, but if you click on long enough, you will be able to get through. You can find out what recent overflows have happened up to about 3 months ago. And then if you're interested in anything else Save the Sound is doing, you can just Google Save the Sound legal docket and it'll take you here. And particularly, so are you seeing that? Is that coming on, Ann? It's still the PowerPoint?
It's still the PowerPoint right now. Yeah, I can
Okay.
put a link in the chat.
It's linked there, but if you're interested in detailed information about the Westchester case, click on the Save the Sound legal docket and go to Westchester, and there's a chart there which gives the status of every town when it was settled, what the environmental benefit payments were, and what the relief was, and how many lines of sewer they studied and repaired, and all that. So you can go town by town, Rye, Worcester, whatever you want to do. So that's the presentation, and if there are any questions, Idan and I would be happy to try to answer them.
Thank you so much, Roger and Adan. I did put the link for the legal docket in our chat. And as Roger said, if anybody has questions, feel free to unmute yourself and jump right in. Or if you're more comfortable, you can put stuff in chat. David, did you have something?
Yeah, this is David Ansel, Roger and Edon. That was amazing and filled in some gaps. That was really excellent, and really proud to be part of the organization that did this. It's great work. I had just a technical question on the ordinances and the opt-in and opt-out. If you could just touch upon that one more time, because I just wanted to understand it.
Sure. So two different things. An ordinance is a law passed by a municipality, which requires at the time you sell your house or at the time you do a major renovation, that you have to have a certification from a plumber or other sort of qualified professional, that your laterals are in good repair. So they don't look like this, and that you don't have illegal sources of discharge into the sewage system, like a roof drain or a basement drain. So that's one thing, and that's, a city inspector. When you pull the building permit, or when you sell the house, you have to touch the municipality at that point, so they can require that certification at that point. And then the insurance program is something a little more complex and innovative, but more effective. And it really starts addressing the situation, the reality that these are very big expenses and burdensome for homeowners, and you don't budget your lateral sewage, your 100-year-old lateral sewage line having to be repaired. So you can opt in for very reasonable amounts, or not opt out, hopefully, but if you participate, you contribute very reasonable amounts, $10 to $20 per month, and you're not on the hook. And the town will decide which pipes need to be fixed, and in what order. So they're getting the worst pipes first, but you don't have this huge unanticipated bill, and the fate of the sound is not dependent on you having budgeted this huge thing while everything else is going on. So that's by far the best. And we'd also like to see funding for low-income residents included with that for obvious reasons. So that's the best long-term solution. And like I said, the town of Harrison did agree to do that, and they're implementing that. So we're hopeful about that, and almost all the towns have done ordinances. And
Right, so
we have
was it part of the settlement, or was it a suggestion?
part of the settlement.
Okay, that's what I want to make sure. Thank you.
Hey, any other questions? Feel free, jump in. Rafe, did you have a question? You're on mute.
I'm sorry, this is Ray Felkind. I apologize. That was incredible, Roger. And I want to thank you for that. But how does a homeowner, pay that insurance, and how is that publicized to homeowners that they could pay that $10 or $20 a month to have that coverage?
So ideally, it's an opt-out. So it's something that you have to pay the town, unless you tell the town affirmatively you don't want to pay, and you'll be billed for it or have some payment mechanism. If it's opt-in, then you agree to opt into the program, and it may be run by the town, it may be run by a private company, and you have a monthly payment associated with that. Like we said, by far the best ones are run by the town, and they are opt-out because the whole point of an insurance pool is you need a significant pool. If I'm the only one who signs up, then it has no impact whatsoever, and I'm in the same position. I'm just paying it early as opposed to later.
Got it. Makes total sense.
So I'll just add, I live in New York City, and New York City has an opt-in program, and I opted in, and I think I pay $7 a month. I live in a 100-year-old house, has a 100-year-old pipe. The Roto-Rooter guys have come out once to clean it out. I know that the next time I have to call them, the pipe is going to collapse. Between then and now, I don't know how much I will have put into it at $6 a month. But I sort of think about it as prepaying so that I don't get a, $2,000, $3,000 bill down the road. Anyway, there's logic to doing it this way.
And then we have a question in chat from Joel. Did the municipalities hire their own engineers, or was there one assigned to them by the courts?
Oh, I wish there had been one assigned to them by the courts. No, every town has its own in-house, that's a bit facetious. It's actually very important. Every town has its own in-house engineering staff, and every town has its external engineering consultants, and both of them are involved in the case. Some of the municipalities are so small that they don't really have a true engineer on staff. They'll have a Department of Public Works that is 1 or 2 people, neither of whom is an engineer, but they're responsible for running the system. But both those people and the outside consultant work together, and the consultant will provide all the technical knowledge that the towns don't have. And that's sort of why the towns have them on retainer, or they use them for when they need to drop diagrams of new plans or get permits or well, anything that you would need an engineer.
And it's mostly consultants. We found when the towns have hired the bigger consulting firms that there tends to be a lot of agreement, and there isn't that much back and forth. When they hire sort of some smaller, less resourced consulting firms, there can be a lot of disagreement and a lot. So we actually kind of prefer working with the bigger outfits, even though they're technically on the other side. We want people who really understand the systems and understand how to solve these problems.
Okay, and then in the chat, we also have a comment from Julia that on private lateral insurance, the city of Rye has identified a sewer line protection program serviced by the American Water Resources that residents can privately opt into. So she shared the link there for that if you are a resident of Rye. And we're at 12:59 now. If anyone does have more questions, feel free to email. Both Roger and Adan have said that they would welcome an email if you do have a follow-up question. And thank you all for being here this afternoon, and thank you to Roger and Adan for this great presentation. It's really helpful.
Sure.